I'm Councillor Conda and I'm Chair of the committee. This meeting is being live streamed on the Council's YouTube channel. The recording of the meeting will remain online for 4 years, and if you're present in the chamber, you are consenting to appear in the recording and broadcast, which may also be used for training purposes. Before we proceed, I'd like to remind everyone that this meeting is conducted in accordance with Gloucester City Council Constitution, which sets out the rules and procedures to ensure efficient, transparent and accountable decision making. Planning Committee members have received and read the detailed reports of planning officers on the agenda from the planning officers on the agenda prior to tonight's meeting. And to the public in the gallery, if you've registered as a speaker on one of the substantive items, you're consenting to the use of sound and video recordings for broadcasting and training purposes. When we reach the public speaking slot for an item, I'll call you forward and ask you to make your 5-minute representation, and I will give you a 1-minute warning if you would like that. Agenda item 1 is apologies. We've got apologies from Councillor Stephanie Chambers, with Councillor Gravel substituting for her, and from Councillor Marshall with Councillor James substituting. Are there any other apologies? No, thank you. Now, declarations of interest. Do any members present have any declarations of interest in any of the items on the agenda tonight? No, thank you. Agenda item 3 is the minutes of the last meeting. Are members content for me to sign them off as an accurate record of what happened last month? Thank you. Now, we've had some late material. Have members reviewed all of the late material? If not, let me know so we can take a few minutes to make sure everybody's had a chance to read and digest everything. Okay, all right. Do you want a couple of minutes? This is agreed to amend the agenda so that we deal with the Linton Fields application first of all, and then we'll go on to the Wheatridge application and Painswick Road after that, and then the section 106 update. So will members please now move to agenda item 6. So we're now on to the first substantive item. Can I ask the Principal Planning Officer to introduce the report?
Thank you, Chair. This application is for affordable development for 54 affordable dwellings, open space and infrastructure. This is a site location plan. The application site is 1.67 hectares in size. It's located to the southwest of Nas Lane. There's hard standing. There's hard standing to the north of the site here. And there is the poultry farm here and the application property known as Linton Fields, which is not part of the application. It's an aerial view of the site with the application sites here. You've got, it's a mixed area of commercial and residential. It's residential here, further down here, and there's commercial there. The site is very close to Boothway Open Space, which is located here. On this side here, there is a car park and grasslands, and then obviously the commercial warehouses there. Got to put my glasses on. This is the site layout, which identifies all the properties. And closer up to the properties, the red dots identify the Section 106 social rented properties. The yellow is for the applicant and the additional social rented, and the blue is for the additional shared ownership. That's the top end, and that's the middle end and the bottom end with the open space. So there's the red is the 106 social rented, the yellow is the additional social rented, and the blue is the shared ownership. Some street view elevations. This is the elevation from Nas Lane, looking into the site. It's taken this view into there. This elevation is taken from looking from this way across the site, showing these properties here. This elevation here is showing the site looking up this way. And these elevations are looking up this way. And then the final street elevation is looking from this way into there. You can see that the land slopes down towards the bottom area there where the suds is to be, and a small area of outdoor space there. In terms of elevations of the properties, these are the bungalows. And the walk-up flats, and they are 1 bedrooms, 2 bedrooms, the walk-up flats. These elevations, this one here is 2 bedrooms, 3 bedrooms, which is M42 semi-detached dwelling. And this one is the 2 bedroom, 4 bedroom M42 semi-detached dwelling for different styles. This one is the 2 bedroom, 4 bedroom M42 semi-detached, and 3 bedroom, 4 bedroom semi-detached. And this is a corner dwelling for 2 bedroom, 3 bedroom, 4 person. And this is a 2 bedroom, 3 bedroom, 5 person semi-detached property. Again, these are elevations, and then these ones are the 3-storey buildings, which are 4 bedroom and 7 persons, 4 bedroom and 8 bedroom person, and the last one is the 5 bedroom, 9 person properties. The scheme comes with some landscaping, and this is the landscaping for the top end, which includes street trees, grass round the edges, more detailed within the site, the grassed areas, the trees, trees, and then the very bottom bit, which is the outdoor space with the walk around there, the suds, the pumping station, which is landscaped around to reduce its impact and its visual thing, and then you've got the footpath that goes from the site and into the public right of way. In terms of the public right-of-way, EQ18, which is the public right-of-way, this is a definitive map, comes down from Nas Lane towards Booth Lane open space, and EQ19 goes across this way. At the point where EQ18 and EQ19 meet, there is a kissing gate, which would be upgraded. This is the view from EQ18 down towards the kissing gate, and this is EQ19 from where the kissing gate is, and that is the kissing gate, and that is viewed from Booth Lane open space. This will be upgraded to allow for cycle access for cycles, because the actual cyclists aren't public right of ways for walking only and not for.
No, it's just upgraded.
It's just upgraded.
To it's more accessible.
To make it more accessible. Yeah. Okay. Thank you. This is Nas Lane looking out towards the residential, commercial opposite, and about where the access site is. This is looking towards the corner where the national speed limit is currently, and it is proposed to amend the TRO to take that further around the corner. This is the actual application site, these photos were taken from the public right-of-way EQ18. That's looking up towards the northeast towards Nas Lane, and this is looking southeast towards the rear boundary. And the application is being recommended to approve, subject to conditions. Section 106 are set out in the office report and the updated information.
Thank you very much. We move on to public speaking now. We have no members speaking this evening, so I'd like to call Joanne McGrath to address the committee. You have 5 minutes. Would you like a 1-minute warning? Okay.
Good evening, councillors, and thank you for your time. My name is Joanne McGrath, and I am the planning consultant acting on behalf of Vauxhall Developments and Platform Housing. The application seeks full planning permission for 54 affordable dwellings to meet an evidence need for affordable housing on this previously developed site. The scheme is a solution to families in housing need to access a quality, affordable home. This is a sustainable site which is very well connected to local services, schools, employment and public transport. Members will be aware of the significant pressure on housing delivery across Gloucester. The council is not able to demonstrate a 5-year housing land supply, and therefore the delivery of an affordable housing scheme like the one before you this evening must be afforded substantial weight. The scheme provides a range of house types, from 1-bedroom apartments to 5-bedroom houses, ensuring a balanced and inclusive community alongside accessible and wheelchair-adaptable homes. Housing strategy officers conclude the proposed tenure of the properties, being either affordable rent or shared ownership, is considered acceptable. There are no objections from statutory consultees on technical matters. The applicant has worked positively and proactively with officers at both Gloucester City Council and Gloucester County Council to ensure all technical matters have successfully been resolved. Ecological impacts will be mitigated through on-site measures and off-site contributions to ensure biodiversity net gain. The scheme will deliver a number of highways improvements, which include a financial contribution towards a bus stop upgrade at Marconi Drive to provide new shelter and real-time passenger information. New pedestrian and cycle connections, which will link into the adjacent public right-of-way, are also proposed as part of the application. These measures not only mitigate impacts, but actively try to enhance connectivity and accessibility for both new and existing residents. The layout ensures good residential amenity with appropriate spacing, natural surveillance and private gardens for future occupants. A suds attenuation pond, pumping station and landscaped areas is provided at the southern end of the site, and a footpath will run around the pond with a link to the adjoining public right-of-way. In summary, the proposals before you provide much needed affordable family homes on a previously developed and sustainable site. This is a policy compliance scheme which will deliver significant social and infrastructure benefits to this area. I respectfully ask that you vote in line with your officer's recommendation to approve the application this evening. Thank you for your time.
Thank you very much. Can I ask Mr. Nick Hartshorn to address the committee? Again, you have 5 minutes. Would you like a 1-minute warning?
Chair, members, thank you for allowing me to speak this evening on behalf of myself and my very, very elderly neighbours. I have lived beside this site for nearly 28 years. One of my neighbours has lived there for 75 years. In all of that time, we have faced constant uncertainty, repeated applications and the stress of never knowing what we were placed against our homes. Every proposal has been rejected on highway grounds. Nothing about the access has changed, but the way our concerns are being treated has changed dramatically. It is deeply concerning that the real case officer with decades of knowledge of this site is not here tonight. She has constantly rejected previous proposals due to highway safety, the over-intensification of the private track. That history is directly relevant, yet much of it is missing or deleted from your planning records before you. Over the years, applications for commercial use, mixed use, most recently a car boot sale, were refused because of access onto Nas Lane were considered far too dangerous. Nothing about Nas Lane or the private track has changed. There was also a substantial supplementary planning document in 2009 titled Land East of Waterwells, which reallocated this land from employment to residential as part of a joined-up strategy with major infrastructure improvements. That document made clear that the land was intended for enabling development and not a standalone site like this has become. None of this appears in the planning history before you, despite its direct relevance. Turning to the access, the report repeatedly refers to this private track as a Class 4 highway. It is not. It is a private access road with questionable public rights of way over it. The developer does not own it, cannot maintain it, cannot upgrade it, cannot guarantee its long-term availability. It therefore cannot form part of a deliverable travel plan. And that is the real issue. The applicant is relying on this track to provide access to a bus stop, not a play park, because without it, the travel plan fails. It is also critical to the state that the developer, even with a traffic order, cannot close or obstruct this track at any time. Our vehicle access must be maintained at all times. That is the law, and it is written into our deeds. This is already established with the permission to 97 Taylor Wimpey homes, which were approved on the assumption they could interfere with our access, but legally they cannot. The result is none of these houses comply with the planning conditions imposed on them. If these conditions cannot be met, in practice, it raises serious concerns that the council may again approve a scheme that relies on conditions which cannot be enforced once properties are built. The proposed pedestrian spur onto the track has no visibility displays whatsoever. Cars use this 8-foot wide track at all hours, sometimes at speed. Since it was reopened 3 weeks ago, footfall has increased dramatically. At this development, the potential rail station is 4,000 houses at Brookfort Wadden, and the risk of a serious accident becomes a reality, especially for children running to this adjoining playground. The highway officer also suggests lighting on our private track. Even light spill from this development is a material change requiring landowner consent, which has not been given. Lighting would urbanise the route, harm residential amenity and increase nighttime nuisance and antisocial behaviour. Public rights of way cannot be lit without the landowner's agreement. Our rights are protected under common law, nuisance law, light pollution regulations, planning conditions and land ownership. This applicant can also not fell trees on land they do not own. This is a criminal offence. After 27 years of pressure, this application feels particularly spiteful. The pumping station is placed 10 metres from our home, directly beneath our windows. with a 24-hour operational plant use, noise, vibration, odour and maintenance traffic. No assessment has been provided to demonstrate this will not harm us. The highest impact socially rented units are clustered against our boundary, with shared ownership pushed to the top of the site. The road layout suggests a future linkage directly under our bedroom to Cockwell Drive. And the new postcode GL2 2FU shows a level of insensitivity that is frankly astonishing. These impacts are unavoidable, unjustified, and contrary to the requirement for good design and the protection of our residential amenity. Finally, after 27 years of applications being rejected on highways ground, it is troubling that the same constraints are now being treated as acceptable simply because the tenure has changed. Planning decisions must be consistent, evidence-based, and grounded on the physical realities of the site, not on who is funding the development. The constraints of Naz Lane and the private track have never changed. The committee should not be asked to ignore decades of established planning judgment. A public right-of-way gives the right to pass and repass, nothing more. A simple pedestrian spur does not create a compliant access route. Without secured pedestrian route, the travel plan fails, and so does this application. For these reasons, I respectfully ask the committee to refuse this application. Thank you.
Thank you very much. Would you mind turning your microphone off, please? Thank you. Thank you very much. We move to members' questions. Are there any members who'd like to ask questions that are of material consideration to the application? We're not in debate yet, so please save any comments until we move into the debate section. Stick to direct and relevant questions which are not already covered in the document. Who would like to go first? Councillor Lewis, and then Councillor Reader-Holden, and then Councillor Chambers, please.
Right. It seems to be a lot of the arguments there were about highways and stuff like that. Could I ask the highways officer to explain why possibly the recommendations have changed from last time? If they were rejected on highways grounds, why are they now okay in your eyes?
Thank you, Councillor Lewis, through you, Chair. Our planning history did not reveal any previous applications that were refused on this site. So unless there is any information from the planning officers to the contrary, I'm not aware that that is a material consideration.
The officers just clarify any applications that have been or have not been.
Thank you, Chair. The planning history that is of relevance is set out in the report. I've just had a look on the uniform system. There's no other applications that were either refused or went through to the decision. So we have applications that were returned. We have applications that were withdrawn. Applications that were granted are for extensions to workshops and works at the chicken farm establishment. Application that was granted for new access and gateway and wall for the compound around the field at Linton Fields, fencing around the field, and another one for another walls around the field. That is the complete planning history that we hold.
Thank you. Councillor Reader-Holden next, please.
Thank you, Chair. My question is about the public right-of-way, EQ 18 and EQ 19, which are both shown on the Gloucestershire public right-of-way map as footpaths. Yet we were told that a gate will be placed so that it can be used as a cycle path. Did I misunderstand that? I heard something about a gate and cycle access.
Thank you, Councillor, through you, Chair. I was trying to clarify that point as the planning officer was presenting that. No, the recommended condition that relates to this gate is our recommended condition 4 for pedestrian and cycle access and off-site highway works, whereby no dwelling hereby permitted shall be occupied until the pedestrian and cycle access arrangements and associated off-site highway works shown on drawing P20146-001L, the proposed vehicular access drawing, have been constructed in accordance with details approved in writing by the local planning authority in consultation with the highway authority. The works shall include, but not be limited to, A, the pedestrian link to the public right-of-way AQ18, including a gate installed in accordance with BS 5709, 2018. That, for clarity, is a replacement of the Kissing Gate, just to upgrade it to the later standard Kissing Gate design. That is all. That's all that element is. And B, tactile dropped curb crossing points and associated pedestrian visibility displays. And C, cycle signage lining and tactile paving, including diagram 1057 markings, cyclists lead carriageway and cyclists rejoin carriageway markings. The reasons are as given. It is parts B and C of that planning condition are within the highway extent on Nass Lane. They're not on the private track, which also has the public right-of-way designations across it. The only element of that off-site works is the works to the Kissing Gate, which are in relation to our public rights-of-way improvement plan and are simply an upgrade to an existing Kissing Gate facility to bring it in line with current standards.
Thank you. May I ask about that Kissing Gate? Will it be accessible for people in wheelchairs?
Yes, I understand that is the purpose of the upgrade to the Kissing Gate. It's to make it inclusive, accessible in accordance with our public right-of-way improvement plan to improve inclusive accessibility on the public right-of-way network.
Councillor Chambers?
Thank you, Chair. I know there's been 18 letters of objections received from neighbours and residents in the immediate area. One of the main concerns was that consultation, including claims not all residents received notification letters. That shows that there could potentially be many other residents that haven't received letters that have got concerns with development. What was done in response to receiving those complaints that letters weren't received?
Thank you, Chair. Thank you, Councillor Chambers. We met our statutory duty to notify everybody of the planning application. The letters were all sent with the system logs when they're printed. As far as I'm aware, nobody that should have been notified has been missed. So when it comes to this application, we would have a site notice, and also anybody who is touching the red line of the site would also get a letter. So those are the people that are required to receive a letter, and those are the people that did receive a letter.
Thank you for that. I do have concerns around that because I myself as councillor have not received letters that have been told that have been sent in the post from the council. So there is concerns around that. Also, I've seen in times printed posts that have come loose or not been printed or been defaced, or weather's attacked them and you can't really see them and they're illegible, you can't read them. So that concerns me that not all residents had the opportunity to write in. My second question is around, we had a speaker today, a resident, that mentioned that they're concerned about the treatment plant and smells. Looking at the concerns raised by neighbours, I can't see any comments in response to that. I've checked under character and environment. I've also checked under drainage and infrastructure, pages 40 and 41. Why is there no response to the concerns raised by the residents?
Can I just begin, because we've got some legal advice on the first point you made, I think, about communication.
Yeah, you referred to neighbours not being notified. The legal position is that under the General Development Procedure Order, a local authority only has to notify adjoining and nearby owners of premises who might be affected. There's a certain discretion placed upon local authorities as to whether they should go beyond that. Some local authorities do go beyond, but it's a discretion only. So there's no hard and fast duty to go beyond those who are in the proximity of the development, which is what I think the planning officer has now said, was adhered to. So there's no question from a legal point of view that there's been no breach of a duty to inform. So it's not as if this application is defective because individuals who should have been, it's not a completely open-ended duty. It is a duty which has restrictions, as I've explained.
Okay, thank you. Thank you, Chair. So the application was assessed by our environmental health specialists and they did not come back with any concerns with regard to the application.
Thank you. My question was around the points raised by the publics and their objections. Why it's not listed as a concern raised. You've got concerns around HGVs, you've got concerns about surface water, concerns about environment, but there's no concern raised in that and no response. Page 40 to 41.
Through you, Chair, thank you. Yeah, this only provides a summary of the responses. So all of the letters were received and they've all been published online and are available for scrutiny. This provides a summary of all of those comments. So it doesn't cover absolutely everything word for word, but it does provide a summary of the key matters that were raised.
Thank you for that. Your comment about it's been printed online so it can be scrutinised. That's my next concern. Gloucester Wildlife Trust, I noticed printed out many concerns around the development. And I noticed that it's not in here at all. I looked under section 6.5 on page 47, ecology and biodiversity. And there's no comment whatsoever on the 2 pages about Gloucestershire Wildlife Trust and their concerns about the biodiversity net gain. Why is that? Why is critical information being left out? I appreciate they're not statutory, but it's Gloucestershire Wildlife Trust, so it should really be taken into consideration.
Through you, Chair, thank you. Their comments were taken into account. The ecology and biodiversity section is formulated based upon some of their responses. It doesn't specifically say Gloucestershire Wildlife Trust, but we are not ecology and biodiversity experts. We rely on the comments that they've given us back to the application, and they were satisfied that with the conditions and the detail that's given in this section of the report and in the conditions, they were happy to recommend approval subject to those conditions.
Thank you very much. My very last point before I give the chair the opportunity to ask other people ask questions. I noticed the tree officer said that the best tree in the area is being removed at Ash, which is, their words, very disappointing. Why was that tree not going to be saved in the design when it's obviously a critical tree that the tree officer's made a specific point about?
Yes, the actual tree that the tree officer was concerned was going to be is actually not going to be removed. So he was pleased that that was going to stay. So, and that was, yeah.
Been overturned, that decision. Yeah. Thank you.
Thank you very much. Councillor Castle next.
Thank you. I'm just wanted to confirm really that the affordable housing is going to be all social rentable houses. And not affordable rent.
Through you, Chair? Yeah. Can I do your mic?
Yeah, sure.
Thank you. The mix is outlined in section 2.24, 2.25 of the report. So of the 54 dwellings, which are a mix of 1, 2, 3, 4 and 5 bed properties with flats and bungalows and houses, 100% of that is affordable. And that's a mix of tenure of affordable rent and shared ownership. So 19 of the dwellings would be the M42 bungalows, and some of them are the M43 wheelchair. But as terms of the breakdown, let me find the right part for you. It is in here, I've read it many times.
The breakdown is at the beginning, I think. It's the beginning.
Have you got
Under the proposal.
Oh, there we are. Thank you, Erica. So, sorry, take you back now to 1.2 on page 36. 19 meet the M42 standards. The 2 bungalows meet the wheelchair standard. Oh, where's that gone? Excuse me, sorry. I'm having a moment. Just bear with me.
Is it part of the extra, oh no, that's the section 106 stuff, isn't it?
Thank you, Councillor. We found it, 6.75. We found it in the end. There we go. 11 social rent. There we are. Thank you. And then the additional 43 is 80% of the overall provision, which takes it to the 100. So these additional dwellings, so of the 80, 14 social rent, 29 shared ownership. So in total, it's 25 social rent, 29 shared ownership. Got there in the end. Sorry about that.
Thank you very much.
Thank you. Next, I have Councillor James wanting to, yes?
Yeah, thank you, Chair. My question's similar, actually. As somebody who doesn't sit on the planning committee very often, I wonder when you showed the picture with the red dots, I think it was, for the shared ownership, and then you had blue and yellow dots, and you said that was social rent and additional social rent. What's the difference between the blue and yellow dots?
Yeah, sorry.
It's all secured in the 106. It's a 100% scheme. We talk about nomination rights and the heads of terms and things. So there's various, some of the, if I turn to the right section, some of the units we keep nomination rights for a certain period of time. It's just how it's divided up on the plan, but it's all effectively is all affordable, 100% affordable housing and will be secured as such. We talk about, I don't want to get us confused where in other meetings we've talked about additionality where we're securing affordable outside of planning. That isn't what the case in this situation. This situation is 100% secured through the 106. So effectively, there's no real difference with the dots. Those units that are red or yellow, if I put the plan back up, will still be affordable units. You can find the plan. There's the plan.
There's the plan, yeah.
It makes no difference in terms of the delivery of them, if that answers your question.
It doesn't quite. What my point was will the rent be the same on an equivalent size house? So there's no difference in the letting procedure and the amount of rent payable.
No, there is, it's basically that the red ones are the definitely secured that will stay in perpetuity. And the rented.
In perpetuity.
Yeah, in perpetuity. The one.
And the yellow ones?
The yellow one's the additional social rented, and then the blue one's the additional shared ownership. So there's a section 106 where they are, and ultimately they're all affordable. They're all and some of them are going to be rented, some of them are going to be shared ownership, but it will all be, and it's all part of our nominations. So the additional bits are on the late materials on paragraph 675, which is the social rented properties, including the 6106 and additionality, which is subject to the local lettings plan. So it's all secured by the section 106.
Yeah, my apologies then. Why the need to differentiate between blue dots and yellow dots? I absolutely understand the difference between shared ownership and social rented. What I'm trying to get at is what is the difference between those two lots of social rented housing? Are they being rented out in the same way through the same home seeker system? Yes. So there is no difference there? No, that's the answer then. Thank you.
Clarity achieved. Thank you very much. I have Councillor Tracy with a question.
I don't know where to start first now. First of all, I'm going to say, going back about people being notified, I was always told on planning, it's 10 either side and 10 the opposite way. And that's only the letters go out. So 10 houses there, 10 houses there, 10 houses there, 10 houses there. So that's altered now, has it?
Can we just try and get your name up there? Because got the wrong name there.
I'm just going about, 10, 10, 10, which the gentleman said earlier on about, somebody said no notification. So I just thought it was all 10, 10, 10, 10, but I probably in planning it was 10, 10, 10, 10. Yeah, would it?
Under the General Development Procedure Order, which is the definitive guidance and statement on who should be notified, it is adjoining owners who might be affected by the development. And over and above that, there is a discretion given to local authorities as to who extra they want to serve on. If you've got this 10 rule, that 10 rule probably comes from a discretion being exercised in a particular case. But it's not a hard and fast rule. It doesn't have to be observed in every single case. You can satisfy the requirement by just going around the development, drawing a circle, and anyone affected or adjoining that particular development would be notified. And that would not be a breach of the requirement or the obligation or the duty laid upon a local authority. You would satisfy that duty just by doing that.
Also, I'm going to bring this back up again. I know Nass Lane and everything else, but I still think, and this is a very complicated planning application, which has been here before.
Can I just point out this is still the questioning
I'm just
phase?
going to say, I would like to note that people should do a site visit. Right. Right. Yeah, I'm going to do that in a date, but I'd like to see site visit. I always ask for site visits, anyhow. Right, let's go on to highway then. Right, you got me. What's a Spinal Road? When it says Spine Road off that lane, please. Because, the lane's narrow and everything else, and then it goes on to the Central Road. I'm not quite got that. It's that little Thorpe Road, please.
Good luck.
Thank you, Councillor Tracy.
You're welcome.
Through you, Chair. I'm not familiar with the terminology Spine Road in relation to this application. There is a Class 4 highway that is Nass Lane.
Yeah.
There is then proposed to be a simple priority junction with Nass Lane, entering a street which may or may not be presented for future adoption by the County Council. We've advised the applicant on the form of that new street into the site and advised them on what would meet our adoptable standards for any future adoption of the street. There are then some sections which are shared private driveways which come off that central new street into the site, which is very common on all application sites of this sort of scale. And the street that would potentially be adopted in future ends in a turning head, which is suitable for turning the design vehicles and then entering, so they can enter and exit the site in a forward gear. So in highway safety terms, we've checked all of these details very carefully with the applicants and the designers, and we're satisfied.
Councillor Tracy, sorry, when we've referred to Spine Road in the report, what we mean is that main route through the development. That's what we're referring to in non-highway terms.
Probably I should have known that, but I wasn't quite, because I was along that lane, I wasn't wasn't too sure, but anyhow, I'm gonna move on to, and can I just ask you another question too on this? Bus stops, do we pay for those bus stops? Or does that come out separate? You say highways in the planning application be bus stops, but I thought they were paid separately, bus stops, so that would automatically come in that planning application? Please?
So in the heads of terms in the application, you'll see that the developer will be providing the bus stop at their expense, the one bus stop that we've agreed on Macony Drive. That will be secured through the legal agreement. If committee are minded to grant this evening, we will then go off and write the Section 106 legal agreement, and in that document we will secure the provision of the bus stop. There's
Thank you, Councillor Tracy. Through you, Chair. In our final highway comments, section 11, the first planning obligation that we are requesting is for bus stop infrastructure and contribution. We have confirmed that there is no home to school transport contribution required. No home to school transport requirement. However, we've agreed with the applicants that they will provide, that there will be provision of a bus stop shelter with real-time passenger information at the nearest bus stop to the site in Marconi Drive that serves the application site. It's to be provided with a bus stop shelter with power supply, RTPI installation and widening of the pavement due to shared cycle pavement at that point in Marconi Drive. We expect the bus stop improvement to cost up to a budget of £40,000, and we'll write into that Section 106 heads of terms and the Section 106 agreement that any unspent budget will be returned to the applicant. But it's to be installed by the county council, and it will be managed through its maintenance, and ongoing maintenance will be managed through the contracts we have with the bus operators.
Thank you for that. I'm following on from your question, Councillor. The lane, and I want to know who actually did say owns that lane. The lane is, because it was said earlier on, the lane going through into the estate backwards and forwards, and you're on about kissing. Actually, I've got to be honest, the questions you guys have asked are questions I was going to ask, so well done. But yeah, so with the kissing gate, etc. So who actually owns that lane, please? For I think you did touch on it, but who owns that lane for maintenance?
Thank you, Councillor Tracy, and through you, Chair. I think the public speaker was correct in their assertion that their title deeds would include ownership of the underlying lane.
Right.
However, the definitive map of the public right-of-way is correct. There are public right-of-way footpaths with the right to pass and repass, as the public speaker correctly asserted. And so there are two things in place at the same time. We do not, the legal ownership of the lane is correct. There's acquired vehicle access rights across this lane, this land, that are established through the title deeds to the properties down there. However, the public right of way also exists across that lane, and there is a right for pedestrians to walk in that lane. So, yes, that was why it was so important for me to clarify that no, the Kissing Gate improvement is not to enable cyclists to go through there. There will be no legal right for cyclists to use that lane in future. However, there would be a continued legal right for pedestrians to pass and repass along that lane. It should also be noted that that lane is currently obstructed illegally by one of the properties down there.
That's a problem, isn't it? Sorry, can I speak? To the Chair. with the lane, that lane, is that lighting? Will the developer put the lighting? So there's going to still be no lighting as such.
That's correct. The lighting is not part of the proposal.
I'm sorry, you can't interrupt. I'm sorry, sir, you can't interrupt.
Back on the 4-bedroom houses you want about socialising, because the house desperately needs 4-bedroom houses, don't we? But am I right in thinking there's only 4 going to be 4 bedrooms? I think I am right, but I'm just asking the question, because if we don't ask questions, then people know what they're after.
We've got 5 down here, Pam, for the 4 beds.
And 1.5.
And 1.5, that's in
1.2.
Ah, okay. In 1.2.
With the children, sorry. Am I right in thinking about a play area, a little play area? What you were saying about the landscape going along. Yes. Sorry, then.
Yes, through you, Chair. The actual site is not big enough to have and it's not viable to have its own open space on site. They're providing a small open area, walking area, outdoor space to sit on, but they won't be providing any open space. Yeah, and this site, the nearest open children's play area is in Boothway.
Yeah. Through the pumping station, but I'll leave you to come on to that one. And thank you for now, but I'll go on debate.
Can I just qualify that bit? I do live next to a pumping station in Spoonbill Close, and I don't hear it at all. It's water pumping rather than sewage pumping. So it's sewage, but it doesn't smell. I haven't smelled anything in 20 years, so.
Can we remember this is still questions, not debate? Can we move on to Councillor Gravels now, please?
So, as you know, I'm a sub on this committee, so I asked the questions which perhaps the rest of you already know the answers to. But I wasn't very clear on what the legal colleague was talking about, what we do in terms of notifying neighbouring properties. You were talking about the minimum and then the enhanced and the extra that some authorities do. Where do we sit in terms of notifying neighbouring properties? Do we do the minimum to comply with the law, or do we offer an enhanced wider distribution?
I think our legal representative has answered. If you not, the officer wants to.
Yeah, I'll just to clarify that regularly we bring a statement of community involvement along to council to be adopted. The last one was adopted in 2023, and that sets out how we notify on planning applications. And in that document, it sets out what's statutorily required and what we do at the council. So that's reviewed periodically. It's probably due for review again soon. But that sets out how we consult on on all types of applications, actually. And we have done what we have committed to do and what council adopted in terms of our local statement of community involvement, which also covers that we do what's required statutorily as well.
I'll just repeat that I'm the sub here. I'm the guy who hasn't got all the technical information. But based on what the officer has just said, in terms of the city councillor, we're complying with the law, obviously. So are we doing the minimum, or in that report, in that document you referred to, Ms. Haslam, are we offering a more advanced and comprehensive system of notifying adjoining properties? Is it more enhanced or is it the minimum to comply with the law? That's the question I'm trying to ask.
The statement of community involvement, which has just been referred to, is part of the local development plan. It goes through consultation and is approved in the normal way, like any local development document. So if it says something along the lines of, thou shalt consult so many people, then it has to be adhered to. But over and above that, what you have is what I've just referred to a number of occasions, general procedure order, development procedure order, which says basically you have to do it on a reasonable level. This is what it's effectively saying. It has to be reasonable. It doesn't have to be to the point of saturation. So as long as people affected by it have been consulted, it is not something which can be critical. It is not something which you can criticize the procedure on. So the procedure is quite within, what should be done if you do it to a reasonable level, which is what I understand happened here.
Okay, so to be very clear, what we're saying here is that we do what's required by the law and we don't offer any sort of enhancement. There's zero enhancement. It complies with the law and that's it. Yeah, I'm sure.
Through you, Chair. Thank you, Councillor Gorrell. So for major development, what's required by the law is a site notice or neighbour letters and a press notice. And what we do here at Gloucester, what we did on this application was the site notice and the neighbour letters, that's above what's required, and we did the press notice. So we did more than what's required in this situation, in this case.
That's really clear. I understand that. Thank you.
Councillor Castle.
It's just two questions. Under the terms and conditions with the bus shelter, could we have a timescale on there for when we will have a bus stop? Because it seems to, when bus stops are promised, they take a long time to be put in. And also,
Thank you, Councillor Castle. I think I can probably get there first if it's okay. Yes, we recommended the condition be pre-occupation of the first dwelling. So the bus stop should be installed prior to occupation of the first dwelling.
thank you. And just another question. Most of the residents there will have parking for 2 cars. I couldn't see anywhere when the friends and family are visiting where the extra cars, when they come along with their extra cars, where they're going to park their cars. Are there any extra parking spaces? If so, how many?
Thank you, Councillor Castle. There are visitor parking spaces shown on the plan. We've checked to make sure that there is sufficient space for our recommended number of visitor parking spaces. We usually recommend that they're located nearest to the 4-bedroom dwellings, who are more likely to experience visitors. It is also suitable for there to be on-street visitor parking, in addition to the marked bays. We've checked that the design vehicles, the refuse collection vehicles and things can pass so long as there is a vehicle parked on only one side of the street at any given time. But yes, that's considered suitable.
Thank you.
Councillor Jones.
Yeah, 4.13 drainage officer. Overall, the surface water drainage proposals are acceptable, subject to conditions. So what are those conditions from the drainage officer? I mean, because obviously, with flooding being more frequent and more intense due to climate change, there could be issues about drainage.
Through you, Chair. The drainage conditions are set out on page 57. Just the title of it is on page 57. So it's condition 16. Above that, condition 15 is foul and surface water. Condition 16 is detailed design for surface water drainage. 17 is unexpected drainage issues. 18 is surface water management. So quite a comprehensive list of conditions there. And if you read the details, obviously, they all require information to be submitted to us that's then considered acceptable. So some of them are no development until commencement, and others are should any unforeseen circumstances happen during the construction.
Councillor Lewis.
Just to follow on to my friend over there from Highways. You come out of the entrance, you turn left, that's going towards Questley, you turn right, and that's a horrible little lane. So is there going to be any improvements to that lane whatsoever? Bearing in mind, in the future, it's going to be a cut through to go to Wadden, which is going to be developed. It's bad now, to be perfectly honest, especially around by there's an equine centre there or something like that, isn't there? And just under the railway there. So is there any improvements in the future or anything?
Thank you, Councillor Lewis, and through you, Chair. Yes, this was an essential part of the highway assessment that we undertook. We needed to understand that Nass Lane was going to be safe and suitable for the provide a safe and suitable access for the development trips that were expected. So I note that you've also noted the Wadden developments, and again, we also noted the Wadden applications. So there is a strategic outline planning application in Stroud district that's been submitted on land to the northeast of the application site, seeking up to 2,500 dwellings with access from Nass Lane. This is currently undetermined. These proposals for this application are noted, the proposals in Stroud are noted for context only and did not form part of the Highway Authority's assessment of the suitability of this application site. No reliance has been placed on the delivery of the Stroud application, the timing or layout in reaching the conclusions of this response. So just to note that's how we draw the line there. And in terms of the highway access works, as previously noted, the applicant is proposing a traffic regulation order for a speed limit change, but we have worked with the applicants to consider the safety and suitability of the vehicular access to the site, including the visibility splay requirements on Nass Lane. I think visibility was noted previously. And based on 85th percentile speed observations of current traffic usage on Nass Lane, we're satisfied that a suitable invisibility will be available, and we've conditioned that those vehicular visibility displays are to be provided and then retained for that use in future. And we also on the highway works drawing there's proposal for the speed limit change. So we're expecting that to come through as well.
So basically, after the railway bridge, that's Stroud anyway, but that's where the real bottleneck is going to be. So from a highways point of view, then, in the future, will that road be upgraded? Because it is going to cause a problem, and it will affect, or this will affect it, because an extra, I don't know, 50, 60 cars a day or whatever going up that road, it could be severe, especially when it's raining. I've noticed it's very bad through there.
Thank you, Councillor Lewis. I would just refer you to the live application in Stroud, and I think that as you're correct in assuming that there are concerns with the suitability of Nass Lane further along in Stroud District, for example. However, we cannot justify a request or a highways requirement for upgrade of that as a result of this scheme. This application site does not have sufficient impact to warrant improvements that far down Nass Lane.
And that case, but I just want to put on record, it is going to be a nightmare, and hopefully you will contact Stroud or you'll have something to do with it being sorted out further on, which will alleviate a lot of traffic from there.
Thank you, Councillor Lewis. Are there any more questions? Councillor Chambers.
While I've been here, I've logged online and I've just checked the planning application. I noticed there's more than 18 complaints listed, so this document is incorrect. So I just come across number 19 What's the score with that? If there's more complainants that's been on record than there has been in the file we're getting?
As far as we're aware, that what we have in the report is an accurate record. Some of the objectors may have objected more than once from the same address or the same person. So in which case we would just put them together and summarise as the numbers. There's also a cut-off for responding to the planning application as well. So they may have been published, but they would have all of the points raised were considered by the officer and have been reflected appropriately.
My last question is with regards to the pumping station. Quedgeley Town Council have said it's been investigated that a gravity solution may be available, and that'll stop all the poo smells and stench coming from fowl. Can that not be implemented as a condition that gravity drainage be used as a first call?
Through you, Chair. This is the application that we have before us. This is the solution, the technical solution that the applicants provided, and the drainage officer is satisfied with, subject to the conditions. And we don't have any objection from Severn Trent outstanding on the application either. So this is what we have before us to determine. I couldn't comment on the technicality of whether gravity feed would be possible. What we know is this is what's applied for, this is what works technically, and this is what we're determining today.
Thank you very much, Councillor Chambers. Any more questions? No, we move into the debate phase now. Who'd like to begin?
Yes.
Yeah, Councillor Castle, please.
I just want to make a comment on the pumping station. Miller Homes by me, they've got a pumping station. Yeah. And the reason being is that the level of the new estate and the level of the old estate is at a different angle, so they have to pump it at different levels. And near my house, there is a drain manhole cover. When this first happened, there was a problem. And then when I contacted of smell, and when I contacted the company, they then checked the seal that was appropriate on the drain cover, and they also put chemicals in, and since that time the problem's been solved. I've never heard any noise coming out of the pumping station as well, so whether there's different types of pumping stations, I don't know, but I can say that there wasn't any problem from this pumping station.
Thank you. Councillor Lewis.
Coming back on the, obviously that was just a big worry, the pumping station in 2007 when it was flooded everywhere, sort of thing. And it's not an open system. It's not like a sort of down Hempstead and where, which when they're moving it all around, it does stink. But it's just purely a pumping station, not an open-ended soil sort of thing. So even in 2007, it had no effect on it, and it was still pumping up to. Anyway, that being said, I've got no problems with the pumping station. I do think it's going to become a bit of a rat run all the way through from Nass Lane, but if that's going to be looked at, I've got no problem with that. In regard to the notification of houses and whatever, if you note, 2 sides, if not 3 sides, are car parks and warehouses. So there aren't that many houses around there to actually notify. But like the officer said, they've done the notifications, they've done the site, and they've done it through the papers. So that has been more than covered, like Andrew asked. And in regard to flooding and this, that, and that. If you noticed on some of the drawings, the houses are actually considerably above where the suds are down in the bottom. So I think if those houses flood, we're all in deep trouble. So the housing itself, it is desperately needed, and we have been instructed over the last few years or whatever to give great weight to that. And this is demonstrably bad for everybody. I think it's one of those things that we have to agree to. I can remember this site many years ago was going to be used for a traveller's site. I go back that far. And it's always been there. And I think it's time now that it'll have to be built on. I think it's quite a sympathetic design. It's what the people will need, maybe not the people living in Naas Lane, I get that. But I can't really see anything in planning legislation to actually say against it. It's not ideal, especially on the traffic side of things. I think the people living at Linton Fields, it's been coming for a while and it's been turned down and it's been or not put forward or whatever. But now it's here. As a planning application, I don't think we can actually argue too much with it. No, nowhere's perfect. Bit concerned about the sort of pathway down the side. I think maybe some signs need to be put up saying no cycling. You know, because you know as well as I do, they're going to use it as a cycle path when they're not supposed to. But that's about the only thing I can say about it, to be perfectly honest.
Thank you, Councillor Lewis. Does anybody else? Councillor James.
I'd just like, through the chair, thank you, to reiterate what Councillor Lewis has said. This is really, really much needed, socially rented and shared ownership housing, and we're desperate. We've got, I can't remember how many thousands of people on the waiting list in Gloucester. That's 4,500, 5,000. I think, you know, admittedly there are problems with every scheme when you're looking at Gloucester City because with the lack of land available. But I think this, given the already development up at Booth Way and that Hunts Grove, then I think this is an acceptable infill for that area.
Thank you. Anybody else?
I did like the idea in a nice way when you said, well, it's not an idea. Well, we're here to say yay or nay. You want to meet in having the houses. I mean, the problem, my concern is also, you know, I'm not sure about the mixed houses as such, and we definitely do need housing, but we can't just put them here, there and everywhere, and we have the problems after. And we've got to remember with the roads, etc., I'm still waiting for roads now to be adopted. That's 10 years ago for things to happen. But you're on the borderline with Stroud, aren't you, Council, as well? So it's been going on and on for a long, long time. And as long as it's, you know, it's the housing we need, I appreciate that. But it's that road what concerns me. There's a lot of different things what concerns me. And I'll just say it goes for the vote. But and I can't ask for this to be, you know, put on deferred again because it's been deferred so many times. And just, and as long as there's no windows overlooking the neighbours' properties, I just going back seen a little window on one side. So I'm just going to ask that question like they got in Kingsway. Is there any way we could put soundproofing along where those houses along that field there? Because they do work, a fence for noise, because that's a lot of problems, what the neighbours. Well.
You can put on an informative if you want, but I don't think you can put a condition in because it's not necessary. To make the development viable. So as a condition, it wouldn't stand up. But if you want to put it in as an informative for the developer to take into account, then that's fine. That's not a problem. Thank you very much. Best.
Thank you. Councillor Barmia.
Thank you, Chair. In the view of highly shortage of housing at the moment, and more people are becoming homeless, and there is a big competition of housing properties. So in my view, I think we need to build more housing to avoid the backlog. So in my view, I think we should go for the application. Thank you.
Thank you. Councillor Jones.
I was going to reiterate what Councillor Lewis, Councillor James and Bohemia said. Basically, these houses themselves, affordable, mixed 1 to 5 bedroom houses, a mix of 3-storey, 2-storey bungalows, great, because we see that the benefits of that in likes of Quedgley and Kingsway, where we represent. Highways, yeah, always highways is an issue. But equally, green space is a balancing issue as well. Nas Lane, you've got the railway, the M5, and a bit of issues with low-lying grounds there, but it still passes the test. But in the past, we've lost affordable homes in Podsmead based on green space, which some people would argue it's just for someone to take their dogs for a walk. And that's all I'm going to say. I'm in pro-housing here. Thank you.
Thank you. Anybody else want to say anything? Councillor Chambers.
Thank you, Chair. My concern's really around no open space. To me, it looks like overdevelopment. They've squeezed everything in there. And the space, it's like a little rat run in itself, how you've got to come round and you're going past everyone's house. There's not one house you don't go past. Again, you need play area, you need open space. There's nothing there at all. Industrial units to the sides, and a very busy lane. Andy, to be honest, Chair, Andy with his laughing is really winding me up. He keeps laughing. I'm raising valid points there, and he's sat there laughing like a child. Thanks, Pam, for pointing out. My other concerns about not all complaints are listed. I appreciate you saying that some of the complaints are duplicated, but I can see complaint 8, house number 8, household 8 has been referenced 3 or 4 times. So when they've put in numerous letters, they've come up as the same household number. So there has actually been 19, not 18 complaints. So we haven't got the full details of the complainants. There's been big concerns from Gloucestershire Wildlife Trust about biodiversity, where they've written a 2-page letter around their concerns about the wildlife, biodiversity, natural habitats, hedgerows, that they believe haven't been addressed in the biodiversity net gain plan. Highways concerns, if anyone uses this road, which I do regularly, it's a very dangerous road, the cars speeding down it. There's minimal places to pass by, and you're looking at a development of two households, 2 cars per household. You're looking at 100+ car movements a day, minimum. If people are doing school runs, you're looking at the cars going back and forth. So you're looking at 200 car unit passes a day in what is already a very congested small lane. There's shortage of 4 and 5 bedrooms in Gloucester, significant shortage. Yet there's only 1 5-bed on the whole plot for affordable housing. The foul pumping station, I appreciate there's been some comments saying it doesn't smell. When you pump poo, it does smell. You can dress it however you want, it is a concern. The National Planning Policy NPPF framework states that local authorities should deliver a mix of housing types, affordable, freehold and social, and not putting 100% affordable together because they want mixed and balanced communities. Gloucestershire local plan, the City Council's own local plan states there should be 30% affordable housing, while in this development there's 100%, which goes against what the local plan is. So myself, I can't vote for this. I think it's ill thought out. I think the space is good, and I think it needs less houses on there, more open space, and more 4 and 5 beds. Thank you.
Anybody else? Councillor Harris.
Yeah, on the open space, if you look at the wide area on a map where the path goes through into the back of Booth Way, there is open space around there and a children's play area. So although this specific site within the bounds of it directly, there is only a small amount of open space it is actually in very close proximity to a decently sized area of open space. Pumping stations as well, sometimes they can have issues when they, say, first get installed, but generally these things go in for decades upon decades, and they quietly work away without issues. If anything, it's probably better to have a pumping station than to not have one, because you know that in particularly bad times of weather, it will deal with it much better than if otherwise left. So I think this plan seems reasonable. It seems suitable. It's got a lot of housing that we need. I know there's mention about 30% social housing. I believe that's a target to have at least. It's not it's a minimum. It's not anything over that. We reject it because we do need more social housing. We shouldn't reject it because it is 100% social housing. I think it's an asset to have that much social housing being added to the pot. So I think this is a good application, and we should approve it.
Anybody else? I'd like to add that I like the layout. I think the houses are nicely spaced out. They're not overcrowded. There are no blocks of flats, which we do often see now in semi-rural areas. And I think researchers found that back gardens can be an asset for pollinators. So if we encourage people to actually garden their small plots, it actually could be a more diverse area in terms of botanical and insect life and bird life than we see at the moment. So I don't think we should think it's necessarily going to be a retrograde step in that way. So I support this application. So can I propose that we vote for the application? Can I have a seconder? Councillor Lewis, thank you. Everybody in favour of it? So that's everybody bar one, I believe. And anybody against it? One against and no abstentions. So that is passed. Thank you very much. Right, can we move on to the next item, please? So this is agenda item 4. It's the Wheatridge application. If I can ask the Planning Development Manager to introduce the report. Thank you. Okay.
Thank you, Chair. Just put my pointer, there we are. So this application is at 16 the Wheatridge and it is for a single storey rear, side and front extension with a new pitched roof to increase the roof height to allow for a guest room in the loft. A gable-ended roof over the side and front extension, 2 dormer windows to the front elevation. And all of that will make much more sense when I show you the plans. So this is the property here. This is required to come to committee purely for a constitutional reason in that it's made by somebody related to a member of an employee of the council. Otherwise, we would have approved this under delegated powers. It's in the Abbeydale ward. It's a brick-built bungalow in a relatively generously sized plot, as you'll see there. Got number 14 to the southwest and then number 18 to the north. Taking a look at the property, you can see it's quite set back from the main street, so it's up quite a long driveway, and this closer up photo shows you the current situation. So we've got this garage and utility projecting forward, and then the main bungalow element here. And this property here to the right is number 14, the Wheatridge. This is a photo taken from the neighbour's back garden. So this is in the garden of number 18, which you can see has already had some alterations. The reason we went to this property is because the original design for the application included a balcony, which we were concerned about overlooking, and so was the neighbour, and they objected. That balcony has since been removed and the plans have been amended, so that is no longer an issue for us. This is the application property here, and here is number 14. Now that the balcony has been removed, we're satisfied with the relationship in terms of the overlooking. Here we have the existing and proposed site plans. So you'll see here, this is the front garage that I showed you on that photograph. And this is the neighbour's garage here as well. And then this is the proposed. So we've got a pitched roof, a bit of an extension, a pitched roof going over that garage. This is all single story, that element. And we've got a wraparound single story extension. And then the height's increasing to allow these dormer windows in the front. And now we've got these rear skylights in the rear to allow for a room in the roof. Just move that on. This is the existing floor plan in terms of the ground floor, and then this is the roof plan here. Just had this in to show you the relationship here because this is the neighbouring property. So here we have the proposed floor plan and the proposed roof plan. So we've got, hopefully this is nice and clear, but this element here has got this pitched roof over. And then this element here has the skylights, which are on the roof plan here. And then there'll be, in this proportion of the roof, the skylights and then the dormers to the front, which are shown here. There's a 1.8 metre boundary fence between the two properties, and the extension is 2.8 metres to the eave, so very relatively small in scale. So here we have the elevations of the proposed. We've got the relationship here with the neighbours. You can see, so there's a slight increase in levels here, and then this is a particularly good illustration to show the impact. So you've got a kitchen window here that already looks at this fence, and then it doesn't break what we use, a 45-degree test. It doesn't break that line, so we're satisfied in terms of the relationships there. This is the both side elevations. So you will have read the report. This application has been considered in the context of all the relevant policies and guidance. The proposal is consistent with those policies in terms of design, impact on the amenity of the neighbour, and that's in terms of overshadowing, loss of light. We've also looked at the character of the area and the quality of the future living environment. The proposal we consider is acceptable in planning terms, and our officer recommendation is to grant planning permission subject to conditions. Thank you, Chair.
Thank you very much. There are no speakers on this application, so we move on to members' questions. Are there any questions from members? Councillor Chair.
Right in thinking this is like a bungalow type house, please. Oh, sorry, I thought.
Thank you. For you, Chair. Yeah, so it's a bungalow at the moment, and they're doing that increase to put a bit of living and accommodation in the roof. But it's not a first story extension in terms of there's not a whole extension on the roof. It's an increase in the height of the roof. It's not, so technically it becomes 2-story, but that room is within the roof structure. Through you, Chair. Thank you. No, that's fine. I've just popped the proposed and existing plan back up. I'll just ask Lauren to put that on the screen for you. So that glass elevation we were looking at is that one there. So this extension next door actually comes forward of the proposed extension here. So there's no impacts in that direction now because these are skylights. So you wouldn't. We don't have the balcony anymore. You won't be able to kind of, yeah. And we're happy with the application in terms of loss of light. That's all been assessed by the planning officer who dealt with the application.
Any more?
Been showing us all. Carry on.
Any more questions from anybody here? Councillor Gravel.
Quickly, it's right in the corner from where I live. I think it's a lovely application, lovely road in a lovely part of Gloucester. And I'm glad they took the balcony away and it can sell through. I wanted to just give a plug for this lovely area of Gloucester, one of the best.
Thank you, Gravels. Councillor Gravels, thank you so much. Councillor Lewis, do you want to? No, fine. Thank you very much. And no other questions. Into debate now. Councillor Lewis.
Yeah, I mean, the use of the glass in the back there, I think is fantastic. You know, because it's, you know, your big. I don't know, yeah, but they're if you notice on the new plans of they're having one above the side double doors as well, so that will let in a lot of light, like what Pam was querying about. And I think, you know, regardless from what it looks like at the front, because it's going to look like it's going to be from the front, and that's it. But the back, I think, what a lovely place to live. I think it's wonderful, and it's not just because Andrew lives very close and whatever. No, I think it's a good application.
Thank you very much. Any other debates? It's Councillor James.
I just wanted clarification really, as I don't sit on the planning committee very often, but if this would have been agreed under delegated powers, had it not been, then surely we are really, under planning law, need to vote it through.
Yeah.
Thank you. At that point, well, are we ready to vote on this? Who would like to second it? Councillor Vidahold, thank you. All those in favour of approving? Councillor Tracy? Councillor Tracy, are you? Yep, thank you. Thank you. That's unanimous. Moving on to the next application. Agenda item number 5. This is the Painswick Road application. So we have a case to be presented by the planning officer. Thank you very much.
Thank you, Chair. So this is 10 Painswick Road. It's a simple house extension comprising of the removal of a garage, storage, greenhouse and the erection of a single-storey rear extension and 2 new ground floor windows to the side. In a similar vein to the previous application, this is before members because it's a relative of somebody who works at the council, so it has to come to planning committee for full transparency. So this is the site. You'll see it's on the corner of Painswick Road and Marlborough Road. It has this side elevation presenting to Marlborough Road. Looking at the photo, this is the existing property. It's got a front garden here. Oh, excuse me, I'll go back. Front garden here. It's a classic kind of presenting a sort of Victorian semi-detached with a bay window. This single-storey element in the rear has already been removed, which doesn't require the benefit of planning permission to do that. And then you'll see there's a wall along the boundary here with Marlborough Road. This is that from the other direction. So the garage and the greenhouse will be removed to make way for the single storey extension, which I'll now explain the location of that. So on the left here, we've got the existing site plan, and on the right here, we've got the infill of the extension. You can see the position there on the left. This is all single storey. And then this is the existing floor plan. So just take note of, here's the kitchen, which will be popping out to the side here. I'll show you that in a second. And then a single storey element that fills in the back there where the existing buildings are. So here we have it on plan form. So this is to provide a unit to care for a dependent relative. So we've got a wet room and bedroom, and then the width of the kitchen extended here. And this is just a zoomed in version of this, because I appreciate that's quite tiny. So this is the actual element of the extension here. Apologies, I'm not using my pointer. There we are. This is essentially the extension area. There are some changes on the upper floor, but those are internal changes that don't require the benefit of planning permission. And then we've got, so the additional kitchen width is just, there is the 1.7 metres, and then it's an additional 6.5 metres off the back, and then the 2 new side windows which front onto the Marlborough Road side. I'll show you that as elevations. So these are the proposed elevations. So this is the proposed extension here. Bear in mind that this was originally the garage and the greenhouse. There was already built form in this location. So as with the other application, you will have read the report that this application has been considered in the context of all of our relevant policies and guidance. The proposal is consistent with those policies in terms of design, impact on the amenity of the neighbours, and in terms of overbearing, overshadowing, loss of light, character of area, quality of the future living environment. The proposal is therefore acceptable in planning terms, and our officer recommendation is to grant planning subject to conditions. Thank you, Chair.
Thank you very much. Well, again, we have no public speakers, so we can move straight into questions. Does anybody? Councillor Lewis and Harris, first of all.
Yeah, just a query about the access for wheelchair, because my dad is in a wheelchair now, and we've had to get him a smaller wheelchair because the one that was provided by the county council won't fit through the door, and it is wheelchair accessible apparently. So we've had to get him a smaller wheelchair now, which is ridiculous. So I just want to make sure that this, for the carers and everybody to come in on the bottom floor of the wet room and all the rest of it, they can get the wheelchair through. Because the only difference between the wheelchair that he's got now is because he's got the handrails, so he can do it with his hand. Those won't fit through a normal door. So can we just make sure that it's wide enough, to be perfectly honest?
Thank you, Chair. It's marked on the drawing as just over 1 metre wide. It would be for the applicant to make sure that it meets their needs. There's not really anything I could condition, but it is down as 1 metre. It would have to comply with building regulations as well.
Years ago, and what they thought was right now. I just want to make sure, because if they're going to be wheeling stuff, as a person gets a bit older, they might get a bit more rotund, should we say, and so they need a wider wheelchair and someone to go through. And if you can't get a wheelchair through and they can't walk, we're in trouble.
Councillor Harris.
Yeah, I was just wondering, do you know what proportion of the site would be developed once this is built? Because I'm looking at the outline of the proposed and also the satellite view through Google Earth, and it looks as though we're basically leaving them with a space that's no bigger than 1 or 2 parking spaces as a garden, which I'm just wondering whether that's a bit of overdevelopment of this site. It just seems a bit excessive for the size of land that there is there?
Thank you, Chair. Yeah, it's fair to say that the proposal does obviously reduce the amount of usable garden size. If I pop up the proposed and existing block plan for you to see that the previous development came to here, that was with the garage, and then they had the other structures. So proportionally, it's not that much reduced from what they had before. There's no rules to say there's a certain amount left. In permitted development, that's different. If you're going more than 50%, you have to then apply. But once you're applying, it's for us to assess whether that would be suitable, given that this meets their needs and they're saying that's enough garden for us, and there is still a provision of a garden, and they do have quite a generous front garden. We were comfortable with the recommendation.
Yeah, thank you. That's a helpful explanation. Yeah, I think it is a shame that it leaves it with very, very little garden space, but obviously that these extensions are for a specific purpose, and I guess if that meets their purpose, then that's okay. Just wanted to query whether there was anything around the allowance of garden space that was required.
Thank you. Councillor Tracy.
The party wall, you know, sharing it with another property. Page 30, note 2. Yeah. But, you know, I mean, this has come before, I think. You are right, what you just said, the previous one, yeah, about parking and that. Yeah, the party wall. Sorry, what do you want me to do? With this party wall, is that going to be actually joined together? It's not like a thin gap going through it. Please.
Be fine. Yeah, so the note that we have on page 30 is a standard note we say about the party wall, because the application is touching the neighbouring property. So we always put that condition on. It would then become a civil matter for them to arrange with the neighbour in terms of getting that party wall agreement. But we always add that note to to all of our planning applications really, unless it's very obvious that there's no party wall. But sometimes even the digging of the foundations requires the party wall agreement in place. So we always add that as a note. All of the
I think, well, I think we've established it's a party wall, it's a civil matter. It's what happens with semi-detached properties. I think we're ready to vote now. We've had a fairly... Oh, Councillor Gravel. Is this a question or a comment?
What's the second one for tonight?
Councillor Jones. Right, we're moving into debate.
Debate.
We're in debate now, everybody. Councillor Jones.
Thank you, Angela. I'd just like to welcome residents looking after relatives at home, as we don't have a national care service yet.
Councillor Lewis.
Yeah, I just think this is obviously for a specific purpose with the wet room and the side access and all this. If they can get the wheelchair through, what we do. But yeah, it's just a good use of space. I think they're not losing a great deal off the garden. It's more on the side that they're losing it, which is a bit of a dead ground because they've taken that conservative thing away anyway. So yeah, I think it's just a good use of the size of plot.
Any more comment in debate? No, I think we're ready to move into the vote. Who'd like to propose? Councillor Gravels can propose. Who would like to second? Councillor Jones. Thank you. All those in favour of passing this application? Councillor Tracy. Thank you. Yes, everybody in agreement. Thank you very much. Thank you for that, everybody. We have one more matter to discuss. We have the Section 106 officer to tell us about current progress. Thank you very much.
Good evening, everyone. I'd like to report that we are, as a summary, just to say that we are not in any danger of returning any money, and that we are monitoring our triggers as the audit in 2022 suggested that we ought to monitor our triggers. I'll just go through the report. It's the end of the financial year, so we are looking at our financial reporting at present and as it feeds into the infrastructure funding statement. So we've been receiving funds for Section 106s, and we have been monitoring our income coming in as well. These are ongoing monitorings that we do. So this is just a snapshot of what's come in. I just thought that I'd also show we did indeed return some money last year, but we have not returned any this year, and we are in no danger of returning any money for the foreseeable future. We have also been spending our monitoring fees. We have been spending our commuted sums in terms of our contracts with Ubico, along the maintenance of some of our long-term schemes. And we work in a multidisciplinary team, so that's myself in conjunction with our Parks and Open Spaces team, our Strategic Housing Partnerships team, and one legal to ensure that the triggers are monitored properly. If I can go to the spreadsheet with the various.
Unfortunately, I can't read these spreadsheets. I can if I want to do it, but perhaps next time. I think I'll do it more when this breaks down in a nice way. But very good what you've done.
Through the chair, thank you for your comment, and I'll ensure to make them bigger. I'll just talk through, in which case I'll just talk through the tables. If there's anything that you'd like to focus on or point out, just let me know, and I'll do my best to answer your questions. But for our Parks and Open Spaces active cases, there has been spend across the first 8 Section 106 agreements. So we are spending the money, which is good. That's what we're supposed to do. And we are monitoring new cases and new agreements that come through. So I'm satisfied with how we are monitoring our triggers and collecting our fees and working with the various teams to ensure that, or what shall I say, the experts to ensure that the triggers are being met. For our from our housing and strategic partnerships team, we have about 150, maybe more like 160,000 pounds for commuted sums towards affordable housing. So we're looking for partners in how to spend that money. There are 2 deadlines on the Bristol Road property and the land at Secunda Way, but we are confident that we will find partners to spend those committed sums, and the remaining sums do not have expiry dates. So I'm confident that we are on track with that. We also have our committed sums, our Cotswold Beechwood SACS payments. These are obligations that we share through with other local authorities to mitigate the effects of development on the Beechwoods. So there are conditions which mean that we do take this money, and we have to, and we are monitoring them, like we are monitoring all our other Section 106 covenants. So with regards to enforcement, which is the final element of this spreadsheet, we are still in conversations with the developer for the former Gloucester Academy site around the laying of the pitch. I'm in conversations with the Parks and Open Spaces team, who are speaking to both the developers and local councillors to try and resolve that matter. It is taking a lot of time, but that's where we are at the moment with that particular site. So we're not there yet, but we're continuing to monitor it. With regards to Gloucester Football Club, they have been making payments since July last year, because we ended up taking enforcement action for them to pay their Section 106 contributions for the ecological effects or mitigation caused by the site. The 166 Southgate Street, as a historic case that I'm still in discussions with One Legal about. So there's no resolution on it yet, but I'm still in discussions about that particular site and what is owed and the ownership. That's me done, really, unless you have any other questions.
It's just an update.
No problem at all, through you, Chair. So depending on the type of agreement that we have, usually for our housing 106s, we don't tend to have, or it depends on the agreement, we don't always have a deadline, a spend deadline. For some reason, for these 2 particular applications, there happens to be a spend deadline. I don't think it's usual, but in these 2 cases, there happens to be a spend deadline.
There's also a contribution on there for play.
Yeah. So that's the housing and strategic partnership site, but also from the Parks and Open Spaces site, that same application, there is some public open space funding as well that we are yet to spend. We are yet to spend.
Thank you.
Okay.
Councillor Wiederhold.
Thank you, Chair. I'm just looking at the numbers from the last few years, and in 23-24 we had over 1 million, 25-26 almost 700,000, and yet the year in between that less than 10k, of which we then gave about 70% of that back again. Can you explain why 24-25 is so different from the other 2?
Through you, Chair. I can explain the return of the funds, but I can give some suggestions why the contributions would have been low, but they are not a definitive answer. So we did have to return some money to a developer in that particular case because they were unallocated funds. As much as possible, we definitely don't want to be in that situation where we have to return funds. And historically speaking, Section 106 monitoring has needed some oversight, and it has that oversight, and we are ensuring that it doesn't happen again. But yes, there wasn't unallocated funds that passed the spend deadline, and as much as possible, we don't want to find ourselves in that situation again. In terms of why the contributions might be so low that year, I'm not sure. May I defer?
It would just be that the 106 is signed in that year with those agreements, so we would have had potentially fewer major applications. Could have been the signing of a Section 106 can take a considerable amount of time, so it may be that they were all signed the year before or the year after, but it would come down to the number of applications we receive with Section 106s that were signed that year. So we can only assume from that there were fewer of those in that year. It wouldn't be that we didn't ask in the same way we ask now, if that helps the question, but we can only assume there were fewer applications with 106s in that year. And we may see a decline again going forward, because what we don't have in Gloucester is lots of big sites that can take major development. We've built out Kingsway, we've built out, some of these larger sites that have the urban capacity. So as time goes on and we're left with fewer and fewer sites, there will be fewer and fewer 106 contributions, obviously, as they link to the planning application. So I don't think we're going to get contributions as we had in the height of the Kingsway era, where we had big, 3,000 odd homes coming through with big contributions. Those sites just simply don't exist in the physical environment of Gloucester now. Does that help?
Yes, it does. Thank you. And what I did hear is we now have good oversight of this, which means that we're looking after our money properly now. Thank you.
Are there any other questions? Councillor Jones, and then
Thank you, Angela. It's in reference to point 7, because it mentions Ludlow Drive, Kingsway, public open space, but it doesn't specify. All the others have got, clauses and covenants mentioned, but it doesn't say specifically anything there. I'm just curious, as it's in our ward, that's all. Just mentioned school, so I'm trying to work out what the link is there.
So let me just, so you're talking about the points 6 and 7? Lines.
I think the point is that there's no text here, or there's text here.
I see. I can correct that. Those were taken straight from Exicom, which is our monitoring system. So what it's done is it's highlighted the particular clause, but hasn't given enough detail about that. So I can definitely make sure that that is in place for the next time around.
any other questions? Oh, Councillor James.
Yeah, sorry, I know I keep saying this, but I'm not very often on planning. So that money that's allocated on that line then, is that still to be spent in Kingsway? Has it been spent? If it is still to be spent, is it ring fenced for Kingsway, and can I spend it?
Thank you, Councillor, through you, Chair. It depends on the specific context of the Section 106 agreement. Every Section 106 agreement tends to be tied to a particular area, particular plot, with particular stipulations on how that money can be spent. So even if it's in the area, there may be stipulations about how that is spent, and I'm happy to go offline and talk to you about that.
Councillor Gravel.
Are we just speaking to the report generally, or does it have to be questions? I'm a bit unclear.
You can debate it now if you finish with questions.
Okay, so I just want to make a comment on the report and the reason we're getting them.
It's not a decision, we've just got to accept it anyway, but it's interesting to hear your comments.
Yeah, good, thanks. So the reason we get these reports is that when I was the cabinet member for housing and planning, I took a look at the Section 106 agreements and the records, and it was clear that there were, choosing my words carefully, it was clear that some more work was required on the records that were being presented to us at committee to get some clarity on what was unspent and what was unspent and what was spent in terms of 106 agreements. And depending who you asked, you got different answers. So I then talked to the leader of the council and said, wouldn't be a bad idea if internal audit took a look at this, and the rest, as Andy will remember, and Pam, the rest was history. They found quite a sad story of not too good bookkeeping and record keeping, and monies that had to be repaid. And some of them were on trigger points. So you say, has to be spent by occupation of 250th house. And the developers saw that and said, you've missed that, we want our money back. And that was the sort of thing that was going on. And obviously it broke my heart, especially as a lead member, it broke my heart. So I think I was the first person who's ever said to internal audit, first cabinet person, said, no, things aren't that good in my portfolio. Can you please take a poke around and come up with some recommendations? And they really went to town on it, and the report, which came out on green paper, was quite serious. And so I'm really chuffed. I was talking to Nana before the meeting started with some questions and comments, and I'm really glad that we've got somebody who knows where the pulse is, and not just knows where the pulse is, has made sure that it's okay. And so really grateful for your clarity and your work around Section 106. It wasn't like that until you arrived. And the reason we get these reports twice a year is because that was one of the recommendations of the scrutiny committee where we talked it through. So I'm really chuffed, and thank you for what you do. And it makes it a lot clearer. And we're not in this crazy situation. We have to refund money to developers because we've missed the trigger points. Chair, just finally, that puts it in the context of why we get these reports.
Thank you. So, are we happy to accept? Are we happy to accept?
Yeah.
Yes, we are noting the report, accepting it. Thank you, and thank you, Nana, for your hard work. Delegated decisions, agenda item 9. Are members content to note the delegated decisions?
I note that one of the delegated decisions is an application that was refused. However, it was a retrospective application. I just want to know what happens in that case, because I assume that being retrospective, the work has already been done.
Yes, so that would then now get referred to the planning enforcement team for them to decide what type of action would be appropriate in this situation. So it will be with them now.
Thank you. I think we have now finished the meeting. You can all depart. Thank you, everybody. Thank you. Good night.